afternoon to one and all present here. We request our panelists and guests to come forward. Once again, a very good afternoon to one and all present here. I'm Dr. Bindu Ronald, the Deputy Director, Academics at Symbiosis Law School, Pune. Symbiosis Law School, Pune, a premier institution imparting high-quality legal education in India, was established in 1977. It's an institution which has consistently been ranked in the top 10 law schools of the country. India today has ranked Symbiosis Law School as number 3 among the law schools of the country in 2019. We were ranked number 7 in the NIRF Law School ranking in 2019. The vision and mission of Symbiosis Law School Pune has taken the law school to great heights, and we have ensured a good blend of contemporary legal techniques with traditional jurisprudence and practice, which we have evolved over a period of time, keeping in sight the national and the global vision statements. On behalf of Team Symbiosis Law School Pune, I welcome everyone present here to Destination Symbiosis Law School Pune Meet 2020. We conceived this as a platform to bring together the stakeholders of legal education, including law aspirants, current law students, alumni, law firm, corporate houses in a discussion. We also have this as a medium to communicate to our stakeholders our vision and provide a platform for interaction and networking. This meet is meant to provide an opportunity to the young law aspirants to interact with Team SLS Pune to clear any doubts they have towards the end. We hope this meet, which includes a panel discussion, will help strengthen industry-academia relation and contribute to the preparation of the aspirants in making their choices to the right law school. The afternoon will begin with a presentation on Symbiosis Law School Pune and its achievement, and with a talk on why to choose the best law school, scope for legal education, followed by an interaction and question answer. And the second part of the event will begin with a panel discussion, which will be moderated by Dr. Shashikala Gulper, Director, Symbiosis Law School Pune, on the subject Artificial Intelligence and Other Emerging Trends Impacting the Future of Legal Profession. Before we begin today's meet, we begin with a presentation and a video on Symbiosis Law School and its achievement. Sorry. We'll have the presentation on Symbiosis International University, which will be followed by the presentation on Symbiosis Law School Pune.
To dream and persevere to make his dream come true. The story of one Indian who thought differently and made a huge difference to the lives of thousands of students all over the world. Dr. Majumdar, who was the rector of the boys' hostel, was spending a quiet afternoon in his quarters. All the students had left for the Diwali vacation. Only the foreign students stayed back. His attention was suddenly drawn by the sight of a girl student. She was standing under a window of the boys' hostel, secretly passing a small parcel to a boy inside. Suspecting some mischief, Dr. Mujumdar went to the room to investigate. What he saw left him disturbed and distressed. The girl had gone to give some food to a Mauritian boy who was suffering from jaundice. The incidents left a deep impact on Dr. Mujumdar's mind and a deeper void in his heart. He was determined to improve the plight of these international students. His mind was made up. He decided to establish an institute where these foreign students would be able to study with Indian students in an atmosphere of peace and harmony.
Symbiosis was started in 1971, primarily for the welfare of foreign students studying in Pune. But after a few years we thought that education is perhaps the best medium to promote international understanding between foreign and Indian students. Because we believe that foreign and Indian students can study together in the library, stay together in the hostel, play together on the playground. And that is how we started various educational institutions.
Offered at the university is truly wide, and it gives the student an opportunity to really take courses from each of the various disciplines, giving them an opportunity to learn across disciplines. And I think this is one of the most wonderful features of studying at Symbiosis.
Symbiosis is to promote international understanding through quality education. And we have students from different states of India as well as different parts of the world. Our thrust is not only to provide excellence in academics, but to mold personalities of these young minds who come to study with us, to provide a value-based education so that when these students leave the portals of Symbiosis International University, they are better global citizens.
I feel very lucky to be here because it's just simply a way home from home.
I feel very privileged to be the part of Symbiosis since I come across with different people from different countries and background.
The recreation facilities over here are great. They have all the sports facilities, football, yoga, gym, and everything possible, and so much of nature around us.
मुझे अच्छा लगा आपको मिलकर के मैं नहीं जानता हूँ मैं अपनी बात आपको कन्वे कर पाया नहीं थैंक्स chose Symbiosis Law School because it is one of the most prestigious law schools.
Symbiosis broadens your vision because it allows you to go beyond.
We are given a lot of hands-on experiences, not just based in the classroom.
We also have a lot of outside faculty come in and take lectures for us, which is great because it's always good to have a perspective of someone who's working in the field.
The things that we learn in books, they literally make us apply them in real life.
Like we have mood courts, we have a lot of student exchange programs which you can go to.
As a member of the International Law Cell, we are one of the most successful model UN contingents in the country today.
The diversity over here is very vast that you may not find in other law colleges.
There are people from not only different states in India but also different countries.
Even though we've come from different places, the fact that we're all here and we're all in Symbiosis, there's a certain unity that comes with that.
We attract international faculty, we attract international students. So there's a certain degree of leadership as well which is played by this law school. Take it in the area of professional education or in the area of judicial training.
Anyone who is looking for a college that gives them a perfect balance between education and personal development, Symbiosis is the place to be.
Do come to Symbiosis. Everyone has found themselves here in more ways than one.
Dr. Shashikala Gulper has a teaching experience of over 24 years at NLSIU Bangalore, SDM Law College Mangalore, Manipal Institute of Communication, University Law Cork, Ireland, and she has led SLS Pune since 2007. She is on the editorial board of LexisNexis Butterworth, Journal of IPR by CSIR, Law and Policy Journal Dublin, Ireland, Polish Law Review. She is the member of Curriculum Development Committee, Bar Council of India, Academic Council of National Judicial Academy, Bhopal, IALS Global Law Deans Forum, International Consortium of Law Schools, and on the board of many academic and administrative bodies. She is the recipient of AHRB Fellowship, Fulbright Nehru International Education Fellowship, National Merit Scholarship, to name a few. An individual with a passion for research, she has been heading a number of research projects and has been instrumental in bringing 3 EU projects, is working on 3 minor projects of SIU, and she is a PhD guide and has successfully guided many PhD students and has 8 students under her. There have been 8 students who have been conferred PhD also under her. She's also a PhD referee to some of the renowned institutions in the country, such as JNU. I now welcome Dr. Shashikala Gulper on the dais to give the presentation.
Good afternoon, my dear panelists who have come today from various distinguished law firms and organizations, dear faculty and team members from SLS Pune, well-wishers of SLS Pune in the form of alumni, in the form of friends, and the other beneficiaries of today's get-together, which is parents or students who are here and people from other industries who have come to listen to these esteemed panelists. A very warm welcome to each and every one of you on behalf of Symbiosis International University's founder and Chancellor, Dr. S.B. Muzumdar Sir, the Pro-Chancellor and Principal Director of the Trust, Dr. Vidya Eravdekar, our Vice-Chancellor, Dr. Gupte, and on my own behalf as the Dean of the Faculty of Law, which is home to 4 law schools, and as the Director of Symbiosis Law School Pune, the oldest law school in the family. I must tell you at the beginning that as I extend this warm welcome, majority of you are our alumni. Am I right? Yeah. So I will tweak this presentation. I will put the emphasis in a different way because this was meant for an audience which has reasonable mix of aspirant students and their parents, as well as those who are from other law schools, if they are looking at LLM with us, or graduates from other colleges who are looking at undergrad program with us. But I'm sure that the presentation is going on Facebook to the larger audience simultaneously as a live mainstreamed one or as a recorded version. So I better go through the presentation. So I request the alumni to bear with me, because I know that there are many generations of alumni who are here, although numbers could be varying, and different hues of alumni, those who come from the LLM background at Symbiosis Law School, Pune, those who come from LLB background, and majority from the 5-year law program. All of you have made us proud, and you have come back to us in this get-together, and I'm sure some of you have been coming to Pune on official commitment or on personal social commitment. Please don't forget your college. You always belong to us, and we belong to you. I personally believe, and this is the proven scholarly work, research work, which posits that a university or an institution has a life beyond its precincts or its campus. It always lives through the community, and it extends to the community, and it's a it's a meeting point for the community. Therefore, you are never severing your umbilical cord with the institute once you graduate from the institute, or you don't have anything to do with learning with the institute. You can use the institute. I'm using this word. You can utilize the duty of the institute to enrich yourself as well. We tried some faint attempt in Pune in a couple of alumni meet. Once we brought Justice Nandrajog to show you, who is currently sitting as the Chief Justice of Mumbai High Court. I think his tenure is finishing, but a wonderful judge, one of the eminent judges of this country. Sir came to a meeting and he narrated how bad drafting is brought before him by lawyers, and he thought what is not to be done and what is to be done. So we also had panel of this kind with the alumni for their benefit, which was highlighting on legal practice and changing trends. So we use these alumni meet in Pune as the learning avenues. We have had get-togethers in different locations, mainly in Mumbai and Bangalore in the past. But today's meeting was very important for us because we wanted to use this so that alumni could also enrich our discussion. So this discussion, panel discussion we organize is to enlighten the people. It's our aim of education, because we are not confined to campus. So we are going beyond campus, out to the community, a community of stakeholders and others. So can I ask among the audience, how many of you are prospective students, people who are interested in joining SLS Pune? Yeah, there are a few. So I will run the presentation for your sake. How many, how many among those who put your hand up are aspiring to do the 5-year law program? 3-year law program? LLM? Yes. Now, I'm sure the 5-year law program aspirants are very busy cracking their exams and preparing for the CLAT and whatnot, SLAT and everything. So I understand, but I'm sure that they will access it through the Facebook. And this generation is increasingly becoming tech savvy. That's why we kept this topic as well. So because we are getting outdated, we have to continually renew ourselves. Although we don't have much of age difference, today we are speaking of generation in each year, because I see new crop of students coming with new expectations, new talents, and also new resistance so, to the old pattern. They want everything new. So I think intelligence, we are living in an era where intelligence is at its mutated best, and the mutation is happening every 6 months. So the mutants, the mutant genes. The next question is, how the alumni who are here, I don't have to ask the question, but how many students from how many professionals from non-alumni background? That would be a more appropriate question. Other than those who put their hand up to be the prospective students, how many non-SLS background professionals are here? Okay. Non-SLS background professionals, some are panelists, some have come probably to enrich themselves or to contribute to our initiative. And I'm very happy that large percentage of our panelists, or a substantial percentage of the panelists and the respondents are our alumni who have grown over the years even to contribute to our content, and as examiners, as faculty, as visitors, alumni contribute to, we are the front runners in SIU, interestingly. Although SABM has got its prominent alumni in telling positions in companies, we are the front runners in evidences of how alumni have contributed to our growth. I came in 2007 and people say I changed the college 360 degree. I don't take the credit at all. First of all, it's Dr. Muzumdar's vision and the freedom he has given to the leaders who are working with him. And he has made us feel as if he is nowhere there and we are the ones who are the face of the institute and essence of the institute. That translates our energy into the institution. But I could enrich this because of our alumni. The credit goes to them. We had a little, like in every good relationship, there is always a negative experience. I mean, even in the best of the marriages, there would have been anger, there would have been differences. So we have had our own share of differences, but that has not unnerved or weakened the beautiful relationship we share with the alumni and the excellent contribution that they have made. Even the moon has spots. So spots are going to be there. We don't care because we always believe in the brightness which overtakes this. And I once again take this opportunity to also express my deep gratitude to each and every one of you for taking the time out, for validating our little effort, and for strengthening us in reaching out to our future stakeholders. So thank you all. Now let me take you through the presentation. I'm sure most of the alumni would have been through our old campus in SB Road, so they must, through the film, recall some of the abstract experience of SLS Pune, what it stood for, but also concrete reality of the new campus missing. I remember we have Manavendra here and Shubhajit also, and their friends who are missing here. They all would come to this new campus for the meet or wherever we organize the meet, but they take a separate vehicle to go and feel the nostalgia there, all those landmark memories, So the reliving or recounting is something that you must have done as you were watching the movie. So I'm sure that it would quadruple your passion for the institute, your happiness at those days where you were still having your innocence. Some of those spokespersons in the video, I recall one of them I met in the Bangalore destination meet, and he was coming across as a very fully shaped, seasoned professional. With that command, he was talking about artificial intelligence. So we feel so proud. It's like our own children telling us that now you don't need to worry, I'm standing by you, kind of thing, So thank you for all of that. So this presentation we have designed in such a way that there is information to the parents. I'm sure that some of you are already married, some of you must be having school-going children, so this will help you. So don't get bored. It's about how to choose the best law school. Most of the time we go by these national rankings, we go by the assumptions, we look at some alumni and we feel this law school must be a real good factory of great jurists. That's not true. Because there are some good points about every law school, there are some bad points about, or I would use the word, there are many areas for improvement or scope for improvement where all law schools need to learn from each other's strength. For example, today in India, if you look at the history of legal education reforms led by my mentor, Dr. Madhav Menon, late Dr. Madhav Menon, it was with the aim of producing the best human resource in judiciary and legal profession. But we saw that best legal professionals were created, but they were rather in service of private corporations and multinationals, etc. Now, I think that was an inevitable change. I used to disagree with him when he used to loathe that. But I also feel that simultaneously, a lot of state university affiliated law schools, lot of other law schools in the private sphere were producing judges and good lawyers who were public service lawyers. So if you ask me today, I've got 4 of my alumni as on today serving the judgeship in Mumbai High Court. So almost 41 years of existence, 43 years of existence, and producing 3 High Court judges, and all at the young age group, almost 50% of them, definitely going to reach Supreme Court, and 2 being women, and 1 more woman is lined up. She's being a government pleader now. So this is where we feel proud, and more than 40 district, level judges we have created. They started as munsifs and judges, and we have host of corporate leaders that we have created. So I feel that all law schools have their good points and bad points. So if anyone looks up to Symbiosis as the best law school in the private sphere, I must tell you that this journey of being colored as a purely deemed university private law school has begun with the step of being affiliate of Pune University. Let us not forget that journey. So our aim was also in the beginning to cater to the public interest framework of state affiliation, but we got the opportunity to redefine because of the Government of India's recognition conferred on Symbiosis's excellent 3 institutes as a university, and law school was the front runner there. So our excellence saga has been there from the beginning. I must tell you that this year Symbiosis's golden jubilee year begins. It's of Symbiosis as such. 1971, Symbiosis was created as a loose organization of Indian and foreign students, as the film showed. And the first institute that was created was English Language Teaching Institute to facilitate the assimilation of international students. And the first institute which was created in the higher education landscape was the law school. I remember Professor Mitra telling that your journey was similar to Harvard, which created law school first and followed by management school. Next year, SIBM was created. So both of us are in neck-to-neck competition for excellence now. When I came, I remember Dr. Menon saying in one of the speeches, you should also call your law school as flagship. And there was a little bit of reluctance on the face of concerned people. But today, by right, we are the flagship institute of Symbiosis International University, and we have led the management institute. So the moment law school goes, it becomes very easy for public service oriented people to rely on the credibility. So the difference between us and management school is that, or management products is that, we lend that public service and ethical core as much as efficiency. So this is something where I feel very happy standing as the face of this law school and sharing with you why to choose the best law school. This also indirectly says how to choose the best law school, what are the characteristics of the best law school. So my biodata was already shared, so I thought it could help you if it wasn't. So all of you would agree, all of you, majority of you are seasoned legal professionals, that there is no shortcut to our success in our profession. In our profession, there are many avenues where we can use our law degree and our legal acumen, but all of them almost have certain common traits, which is oratory, good command of language, inquisitive nature and attention to detail, logical reasoning, persuasiveness in communication and our approach. You know, somebody will give up something, but we will follow it up. Even if it's a bad judge, we will still follow up. We will pray for the judge to be changing her approach or to be transferred. So sound judgment, writing ability, attitude, aptitude, analytics, and adaptability, which are characterized as 4 A's of our profession, reading habit, and today it is techno-savvy approach. So you will have to look at these characteristics of the 21st century lawyer. Perseverance. Perseverance because you are sitting with the millennials in the law school and you are dealing with the judges who are 30 years before the millennials were born. So you need that perseverance, not to give up. You are sitting with the clients who come from the diverse background of this country where the huge gaps, even in technical divide, we have huge gap. So our profession needs that. Emotional and financial intelligence. We always thought lawyer means argumentative, knowing the constitution like the back of his hand. No, we also need other skills. And time management. Many a times I loathe to say, I've gone as a litigant as well when I was a law student and later on for Symbiosis. I've always seen we are invited to a lawyer's cabin and then we are attended after 2 hours. So this kind of thing, no client communication happening, no question of being responsive to the client. I mean, we must learn from the medical profession where case sheet is drawn beautifully. That's what Carnegie report said, that idealism of the perfection in profession, we have to look up to the medical profession. Why they are idealistic and why we are not? Because there it is the question of life and death. It's like choosing to be a pilot, you know. You can't afford any error. It's your life as well as others' lives. So in medical profession, that kind of precision is required, promptness is required, alertness required, diligence is required. Even in our profession, it is required. We could convert the rich into poor and the poor into rich. So we also need to have these traits of accountability with all these qualities. Our career builds leaders, and the most exciting career is our career because we are oriented from day one. Ours is the only profession which is mentioned in the Constitution. Nowhere in the Constitution any other profession, management is not mentioned, medicine is not mentioned, engineering is not mentioned. Article 20 mentions our profession. So, and everywhere law is held. I mean, rule of law. Rule of law has got legal education as part of it, legal profession as part of it. So, today's legal career spans a vast expanse, being in the law firm, and within the law firm, different kinds of verticals such as, I mean, not only boutique law firms, but general law firms, and within the law firms, different specializations, and within the specializations, different task-based assignments. So it requires people with multiple skills and people gearing those skills through their trial run in the internship and also solid conceptual clarity and practicing the skill and art. We have consulting firms, we have corporates. So I have more or less with our survey and talking to alumni, etc., captured some things like drafting, researching, client counseling, consulting, going to the court. So within the law firms also, these kinds of tasks can be identified. Specialist lawyers. Then we have solicitors who represent the government, and then general counsel at the highest court, general counsels to the government. Then we have tax heads, IP heads within the law firms. There are many other heads. So those who are in the law firm will bail me out, even the project lawyers and things like that, because Luthra sir was telling me how large percentage of his practice is associated with financing and projects. We also know we have a colleague from Fox and Mandal who have very high degree of specialization in that. So especially with the foreign direct investment coming in, the profession has got so many kind of scope and it requires large skill sets. Which law school trains you with this kind of scientific approach is the question that you have to ask. Where is the curriculum synergy with this? Where is the orientation synergy? How many of the professionals are coming and participating in training the next generation? How many of them contribute to the content in the curriculum committees? Like, for example, I have my distinguished alumna, Sachiv Kumar here, who is our Board of Studies Specialization Group member. We have Shupratim here, who is contributing to us. We have Shubhajit there. So, I may not mention everybody's name, but most of you have been our resources, you have been our guiding light. Now we have court-based profession. Court-based, we have litigation. So a lot of our current students are interested in litigation. I think some of the students who are interested went into different kinds of law firms, and some of you are having your own private practice, like Sachiv's own practice. Within that, we have advocates at all levels, then senior advocates by qualifying in the High Court and in the Supreme Court, standing counsels if you have certain affiliation, and then prosecutors, pleaders, advocate general, solicitor general, advocate on record, attorney general after certain level of seniority. These are all the possibilities as you advance in the profession and you find your passion, and you sometimes, as Mr. Jetmalani used to say, that how you use that opportunity to your advantage and the way your contacts click and the networks work for you. Then you have judges, then you have judicial service. It's only a matter of time that in India it's going to be institutionalized. Judicial clerks, judicial academy, you can work with ministerial officers, registrars, court messengers, legal secretaries with the lawyers, e-justice experts. This is going to be the new thing. And conflict analysts and interpreters. Interpreters, especially with the international cases. I was told that in Enrica Lexi case, they had so much of difficulty because of the Italian mariner case, because of the interpretation. And we also have international issues are not just confined to the High Court, they are also coming to the Mofussil Court. In the Mofussil Court, Somalian pirates were produced in one of my neighboring districts. There was nobody who could translate what they were saying, because our system of law is fairness and principles of natural justice. We are a democratic country. So legal system has to follow all those processes. It was quite difficult. So interpretation is going to be a very important skill. We use it time and again. In Pune jails, we have a lot of international prisoners. So we use interpretation in those cases. Sometimes you have to translate the document of someone who has married an Indian citizen from some other jurisdiction. We need interpreters. Similarly, we have civil service. Within that, we have Ministry of Law and Justice appointments, Indian Legal Service, Ministry of External Affairs, UN jobs, Indian Corporate Service job, which is within the civil service itself, and Judge and Advocate General. Every batch has been producing at least one in our case, both in LLM, in LLB 5 years, and now in LLB 3 years also we are having excellent contribution to civil service and this. So what do you do to the aspirant students? And to the current students of mine who are in the law school, they are exposed to this presentation. Their parents are also exposed. You keep a role model. Among our alumni, we have many. Choose a mentor as you go and visit, or you may have in the family itself, and make a plan to win. But when you make a plan to win, please always keep these 3 friends in mind. Your interest. What interests you? If it is something your parent says, your senior, I mean, in the college, we always believe our ancestors who are our super seniors. So your seniors say that this is good, I did this, I never attended class, this, that, you know. So listening to anybody, you will have to see what interests you and what capacity you have. Even if you have best capacity, 10 on 10 in the, now we have the 10 the CGPA system, outstanding grade in some subject. You might have the outstanding grade, but your passion may be somewhere. Your heart says something else. So choose that, you know, and the opportunity that you have in life. So we always advise make A, B, career plan A, career plan B, and then tally on a sheet which one is in your favor. Is it interest alone, or is it interest and ability, or all 3, interest, ability, opportunity? Go for that. All the 3 aligning well, or at least 2 aligning well. And you can try one. But, you know, many of our students have done the law firm journey, 20 hours of working, and then they decide after 2 years to go to Harvard or one of the Ivy League universities or to UK, do their higher studies, come back. Maybe they go back to the law firm, or they open their own law firm, or they combine a law firm career or consulting career with teaching. So I'm telling for the benefit of those who are aspiring. And in my 3-year law course this year, remarkably, a few students have made it to the top law firms who, with passion and interest and hard work. There is no competition as such. It is just that the employers have chosen them because of their personality and their capacity. So we should not ever feel that 3 years is not chosen, only 5 years is preferred, or 5 years should not think it's our privilege that we will get the first preference. It's your personality. It's the skills. I must also tell you that it is 15% of your knowledge, 85% of your win is about your soft skills. And in Symbiosis Law School, Pune, we train in communication skills as part of the curriculum. We train in soft skills as a special component in the curriculum. And I'm happy to share with you, we have a very strong leader in our skill center, a distinguished advisor, Professor Shudipta, who has just joined us from a very lead role, Asia Pacific legal head role, to enrich our learning process, and we feel very, very privileged. And today we have identified a few more, like Ms. Batra, who will be Bhumika, who will be, I hope, kind enough to continue the lead and enrich our students. So prospective students, you will have many more of these youngsters with us, strengthening our team and seeing that next generation of legal leaders are going to be the best in the world, because we are leading to the borderless world. I'm sure in my lifetime I'll see a world where I don't have to open my Indian passport and stand in a long queue. Only in 55 countries we don't have the visa. Rest of the countries we are always treated as people who are looked at with doubt, and unless we have permanent residency or things like that. So I'm sure that it is going to be a law school which is going to create leaders for the world in the legal arena. Already we are very clear on global competencies. That's why our alumni have been distinguished, Bhumika herself is managing the portfolio in an international law firm in UK as well simultaneously. So I'm sure that that's going to be our reality. So we should not look at law as the means of making money, as Prashant Bhushan, whom I respect a lot, on the professional side. I mean, politics apart, all of us are politically different people. Something you could never do otherwise. It's a rich and rewarding experience, sans the money also. So as Jefferson said, studying law is very useful. It makes a person to be useful to everybody, to the neighbor and to the public. Didn't you experience that? Your neighborhood will come and respond the moment they know you hold the law degree, your relatives will ask you, you know. So this is the kind of responsible, it's not the prestige or the joy, it is responsibility that we have. So we are serious people that way. Now coming to how to choose the best law school and what is the life expected in the law school. When you go and search for a law school, always see whether they comply the Bar Council standards. Academic excellence, more than 70% is academic excellence. Who are the faculty? Are the classes happening regularly? Is there a technology-driven precision in running the law school? For example, we invest more than ₹1 crore to run the classes and student development monitoring through the IT governance. How many law schools are investing this way? Course content, what kind of courses they offer, are these courses up to date? Are there a lot of electives whereby student can make a menu or buffet of courses and select cafeteria? Practice readiness. Are students practice ready? How many of the alumni, by the time they passed out, were already working, aside from the campus placement, you know? Like for example, practice readiness in the old law school where I first started my career, where I graduated from. My first batch student started going to a law office when he was in second year in the 5-year law program. Those days they didn't have law subjects in the second year. By the time he was in the 4th year, his senior made him hire a small room. I mean, he was not from a well-to-do family and no lawyers in his Khaitan. And by the time he was in 5th year, he was a national mooting winner also. He started practice in the small town. He went on to become the Bar Council President of Karnataka at the age of 29. And then there were family-based criminal law practices from a particular community, you know, in Mofussil areas, these are family fiefdoms, you know, private practice, civil practices of a particular community, criminal law practice. He was belonging to none of these communities, but he emerged as the topmost lawyer in the town within 4 years of starting the practice. So practice readiness, that is because we had a very rigorous way of managing the court and chamber visits. And personally, we would sit with their diary, we would verify, we would go and visit the chambers in the local area. So when I came to Symbiosis Law School, Pune, I saw these practical subjects being taught like a theory. So first intervention I made was to get the clinical legal teaching and get all the faculty trained, even the full-time faculty trained in clinical legal teaching, which was Dr. Menon's personal passion. I mean, he won the award for that as well. So that is one. So you go to the law school or talk to the alumni or talk to the current students and find out. Alumni achievement, you see, what kind of alumni, what is the kind of peer group, what kind of students come to that law school, what kind of faculty, what are the facilities, are there student development being handled, are the faculty mentoring students? Like I have got 57, I have got about 66, I think Dr. Bindu has about 57. On an average, we have 57, 58 students we mentor. We are a group of 42 faculty. So all 2,000 are directly monitored by us, at least 2 meetings in a semester and online data that we see on how they're progressing. We had more than 27% of students before we introduced IT whose development was not at par. Today, we don't even have 2 to 3%. So there is always a lot of advantage in that kind of law school governance. Culture of preparing them for profession and ranking. Culture means, for example, uniform is a culture. Although now we have liberalized a little bit more, Wednesday and Saturdays we don't restrict them. Students on their own have realized that it is important to be looking like a professional. So that is one. And then the ranking. Of course, ranking agencies are they can be biased, but look at their criteria of ranking. More or less, these criteria only figure out there. And then research also is very important because today no professional can be successful without research. So how is the research credential of this law school? You have to see when you choose your law school. According to Bar Council's statement, about 70,000 people join the profession from 1,215 law schools in the country. So we are in the top 5, top 10. We finished third in last 2-3 years consistently in the India Today ranking. So you have to see that. And because of the international trade and surging economy integration, we need to be preparing the profession for that tomorrow. So our law school, if you look at our vision, it is about international understanding through quality education, and the law school is about quality legal education. And then inculcating that whole world is one family. So global outlook, spirit of national development, health and wellness, so all-round student development, is there in our mission. We have been courageous to break barriers when we started our 5-year law program, 1-year LLM program. Internationalization, legal education is very difficult to be internationalized, but we have got international curricula, we have got international teachers coming and teaching our students. Ours is the only law school which introduces mooting and legal writing through an American faculty every year who comes, stays with us, handholds the students. And comprehensive curriculum, job-ready development, research and publication at the global level. So collaboration is encouraged. Our evaluation is group evaluation, etc. So these are our programs. We have honors programs, BA LLB and BBA LLB. Our law school is the first to create BBA LLB program in the country in mid-80s. Although we had Jodhpur and others also joining us later on. We have almost 2,000 student strength, where 3-year LLB also contributes a substantial student. Now it is about 180. We have research publications. Please take a look at that. We have, as on now, more than 380 publications. Our internationalization shows our visibility in the global fora. Classic EU legal studies, we were the first in the country to start that. And this year, we are going to start master's specialization in EU legal studies. We have got scholars in residence. We have started internships, international internships, and I'm hoping that with this meeting onwards, in addition to a few of the international law jobs that we have been able to take for our students, we will increase those numbers. And our faculty numbers are also very strong. Some of the world-class approaches that we have is robust feedback system, integrating it, admission, only merit-based admission. Again, it is driven, techno-driven, online announcement. And, we had about 2,000 students applying way back in 2007 for our 300 seats. By 2010, it became 5,000. And today, we have 24,000 applications. That is why we have moved to Noida, Hyderabad, and Nagpur. Nagpur was this year. And we have demand from other cities as well, like Calcutta is demanding us to come, Bangalore is demanding, but we don't want to dilute. What I'm trying to say is that our admission process is so well streamlined. It's very open, it's very transparent. So we don't compromise on merit. We have this, you all may know, we had a quota called discretionary quota, which is because we are a private deemed university, self-revenue model, government gives us that permission. But in that also we don't fill the seats these days. We go by strict merit there also. Somebody who is almost scraping through the merit list but missing it by 0.002 or something like that, we help them. But that also, we have reduced it drastically. So this is where we stand. And then we have policy and legal education reform avenue, where I have been personally very active through the Commission and Bar Council. So in the country's legal education also, we have contributed as opinion tank. This is the old figure. We need to up to date. But today I can tell you, most of our alumni have been placed. Every year they get placed. This is because of a robust effort at psychometric analysis and showing them different avenues of making a living. So, which is within the legal acumen. Some of them discover something new about themselves, like we have many startups created by our students in a variety of ways, online. I heard even Bangalore Law School, one alumna created a company which is sold for millions of rupees to Amazon. So these days, such trends are also coming up with the youngsters because of the techno-driven scene. So these are some of the testimonies of our students. One of them qualified to the New York bar out of the sheer support that we gave to this student when he went abroad. We have in our collaboration also more than 55 international universities. And our students go for summer schools and their students come here. This is the Australian delegation and German delegation, etc. So we have been innovative in our teaching and learning. So these are some of the hallmarks: world-class brand, dream impact on students in fostering competency, flexibility in courses, uniqueness. So these are some of the characteristics which we showcase in Symbiosis, and to prove or demonstrate how we are the best law school. We have been innovative, and our focus has been academics, and within academics, we combine the 3 Carnegie criterion, that is the knowledge, values, and skills. So our best practices include this, I told you, mentor-mentee, and the students who have difficulty in legal acumen, we have a support program which you call as remedial, we call it academic success, crisis management, placement and training, and entrepreneurship cell. And in teaching, we do this conformity. Our faculty is also diverse. With the European project, almost all faculty has been teaching abroad, researching abroad, collaborating abroad. And then we have, among the faculty, we have added 2 more patent attorneys as on today. So these are some of our, these are some of our mentors from the industry and academia and the judiciary. Some of them are no more, but rest of them are still helping us. These are some of the law firms which have provided us the content, who have been our mentors, who have provided us job opportunities, and with whom we have had consulting opportunities as well, like National Defense Academies, Accounts Division, Finance Division, Maharashtra Judicial Academy, National Judicial Academy, to mention a few. So this is our alumni profile, and some of you are already here. I'm very thankful to you. So virtually, those legal careers, more than 130 legal careers, we have our alumni in every one of those opportunities. Like one of our alumni is Dr. Bindu Atmaram Shalke. We have back in the college Mr. Abhijit Vasmatkar. So some of the distinguished alumni also serve on faculty, and Dr. Vidya herself on the board of the university. So this is how we have. And our students, as they're studying, they have made their impact. This is Dr. Kiran Bedi giving the testimony to one of our students. Our recruitment profile also, you would see that law firms have been the maximum recruiters to us, and rest of them also go to litigation in either in the Mofussil area or in the city. Then they switch careers as well. 2 to 3 switchovers happen in some cases. So how we are the right place to study in 21st century? Which law school is the right place to study in 21st century? Which offers e-learning, which supports technical support in all the governance of the institute, which has robust IT resource. We spend more than 1 crore in creating learning resource, of which only 40% goes through print resource, rest of it goes through IT. This year we have upgraded only IT with more than 1 crore of investment. So is this the right place to learn? Right place with the right company to learn? Yes. There is a personality development scheme and career and professional development scheme, where we have induction program which inculcates or instills this spirit, then structured career counseling, career mentoring, and career path identification and orientation. So we have some judges on our panel, Justice Fansalkar, who are supposed to be here. She is one of the mentors. We have Judge Deshmukh as the mentor. We have resume writing workshop, trainings. So some of the skill centers development activities are aligned here. And then we have soft skill development in particular. We have student board and other cell representations, which give the opportunity for students to explore their personality and also to enhance. We have financial assistance, which has gone in the form of more than 2 crores of scholarship in last few years, including the government schemes and private scholarships. Now university is giving topper scholarships. Almost 15 scholarships are out there for the toppers in BA LLB entrance exam and BBA LLB entrance exam. We have medals also, Chancellor's Medal, Nani Palkiwala Medal for the LLM topper, etc. Our community legal service program has been recognized by Herbert Smith Freehills with an award, which we again spent on the women prisoners of Pune. You can see the video on the YouTube. It shows how committed we are to the women's welfare and vulnerable community welfare. Our university has adopted 27 villages and hamlets near the university, where we impart the community legal service. We have done it in capacity building with the panchayat. We have done it with legal assistance. We are doing a unique program called Barefoot Lawyering Program in the villages with the NGO, where we are empowering leadership quality women to be police mitra and first responders in case of domestic violence or other criminal violations of rights in the community. We are training some of them as alternative dispute resolution experts in an informal way. So these are some of the snapshots of what we do and how we do this community legal service. So is this the right place? Yes, it is just right place with these highlights of reputation, flexibility, versatile training, state-of-the-art infrastructure. You had seen some snapshots in the film. Best practices, with our experience, we have adopted many, generated many. Some we have innovated for the university also. Comparative advantage. Other law schools are standalone law schools which are in the top position. We are not a standalone law school with single discipline. We are in the company of excellent management school, excellent computer studies school, journalism school, media studies, whatnot. Contribution to legal education as a leader in constant engagement with the academies and law commission, etc. And Dr. Vidya has been on the UGC for 2 terms as a member. Currently also she is in the advisory to Government of India in the higher education. So coming back to our reiteration that prospective student is welcome to SLS fraternity as an extension student or full-time student. Some of the students from other law school who are attending this, please see that you attend more such program to become our extension student. And you can keep a role model or goal and choose a mentor, as I said earlier. Welcome to Symbiosis Law School as a parent, as a stakeholder, because you are not just entering a law school's community, you are entering a justice worker fraternity. We all are in the business of justice as educators and as workers. Thank you for your kind attention, and if there are any specific questions, we invite questions once the moderator or compeer announces. Thank you.
Since we are running a little behind schedule, we will take the question answers on the session that we had just now with the team SLS at the end of the session instead of having it now. And we will now move on with the panel discussion, the much awaited panel discussion on data protection, data privacy, and general data protection regulation. We have very eminent panelists with us to discuss this particular topic. And I will now call upon Dr. Shashikala Gulper ma'am to felicitate our resource persons for the panel discussion on data protection, data privacy, and general protection regulation. I request ma'am to felicitate Mr. Abhishek Rastogi, partner, Khaitan and Company, Mumbai. Thank you very much, ma'am. May I request you to felicitate Mr. Amol Bhat, partner, Waterhouse, Mumbai. Mr. Amol Bhat, partner, PricewaterhouseCoopers, Mumbai. I request ma'am to felicitate Ms. Amruta Kelkar, partner, Economic Law Practice, Mumbai. Thank you, ma'am. I request you to felicitate Ms. Bhumika Batra, partner, Crawford, Bayley and Company, Mumbai. We also have with us Mr. Sangeet Sindan from Fox and Mandal Associates. Ma'am, may I request you to felicitate, sir. Thank you, ma'am. We have Mr. Suresh Nair, partner, Ernst & Young, Mumbai. Ma'am, Thank you very much, sir, for being on the panel today. I also request ma'am to felicitate Mr. Vinod Joseph, partner, Argus Partners, Mumbai. Thank you, ma'am. I also request you to felicitate Mr. Sachiv Kumar, founder SDS Associates. He's also an alumni of Symbiosis, and he has been contributing a lot to the initiatives of Symbiosis. Thank you very much for being with us. And I also request ma'am to felicitate Mr. Supratim Chakrabarti, partner Khaitan and Company, again, our own alumni of Symbiosis Law School, Pune. We will now begin with our panel discussion, and I invite all the panelists to occupy the dais. As the panelists occupy the dais, let me introduce the experts who are with us and who will be leading the discussion. We have with us Mr. Abhishek Rastogi. He is a partner in the Indirect Tax Practice Group in the Mumbai office. Mr. Abhishek specializes in all verticals of indirect tax and regularly appears before various High Court arguing for and representing clients, writ petition, and other disputes. He is an expert in indirect tax, banking and finance, real estate, and in pharmaceuticals. A graduate from Sri Ram College of Commerce, Delhi University, Mr. Rastogi has completed LLB from Delhi University and is also a chartered accountant. He has been acknowledged for his experience and expertise by Legal Era for 40 Under 40 Leadership Awards. We have with us Mr. Amol Bhat, partner, PricewaterhouseCoopers, Mumbai. Mr. Amol leads the cybersecurity team focused on the FS sector and is based out of Mumbai. He specializes in cybersecurity, risk management, and has amongst his clients the largest public and private sector banks in India. In his career spanning years with PwC, he has been closely associated with some of the big projects such as the building sector, Mr. Amol has worked on various strategic initiatives around the globe and has engaged as a SOX compliance expert for one of the largest global oil and gas company. In addition, he has helped various financial sector regulators design and implement cybersecurity frameworks for entities regulated by them. At PwC, he has anchored the Cyber Global Delivery Center program and continues to build the team further with innovative and strategic initiatives. Mr. Amol has authored several articles and security white papers. He's a speaker and trainer at IDRBT and CAFRAL, where he regularly holds sessions on cybersecurity for senior leaders from the financial sector. He holds a master's degree in commerce from Pune University. He is a chartered accountant, qualified certified information system auditor, and has done 3 TP Senior Leaders Program from IIM Ahmedabad. We have with us Ms. Amruta Kelkar. She is a partner at ELP and a part of the firm's corporate and commercial and private equity practices. Ms. Amruta's experience includes structured finance, private equity, acquisitions, listed debt, fundraising, and real estate transactions. She has been involved in several structured finance and private equity transactions and regularly advises private equity funds, corporations, and financial institutions on their structured and plain vanilla investment transactions. These investment transactions include cross-border structures, offshore fundraising, and list debt structures, including documentation for the India leg. Additionally, Ms. Amruta also advises clients on aspects of company law, security law, and exchange control regulation on a regular basis. Prior to joining ELP, she served as an associate vice president with Kotak Investment Advisors Limited. During her tenure with Kotak, she was involved in various private equity and fundraising transactions. She holds a law degree from University of Mumbai. We also have with us Ms. Bhumika Batra, who is a partner at Crawford, Bayley and Company, one of the oldest law firms in India. She possesses vast experience in regulatory and legal experience, specializing in corporate law. She is a law graduate and a fellow member of the Institute of Company Secretaries of India. She is a recipient of scholarship from London School of Economics. She has co-authored the book Treatise on Company Law in 2014. She is a regular feature writer in India Business Law Journal. She has also contributed in various other writings like Company Law Ready Reckoner, Transfer and Transmission of Shares, a treatise, Asia Business Law Journal, etc. She sits as an independent director on the boards of companies like Jyoti Laboratories Limited, Sharp India Limited, Hinduja Tech Limited, Repro India Limited, to name a few. Thank you, ma'am, for being with us on the panel. We also have with us on the panel Mr. Sangeet Sindan. He's currently with Fox and Mandal Associates in Pune. His vast experience includes stints at Indus Law, Startup Advisory and documentation relating to data privacy laws. We have with us Mr. Suresh Nair. Mr. Suresh is a partner in indirect tax practice of Ernst & Young. He is the India lead for the EY Global Customs and International Trade Practice. He also leads the life sciences, consumer and retail, and chemical sector for EY Direct Tax. He has hands-on experience with the Customs and Central Excise Department, having worked with revenue for over 14 years. He has served the elite investigative agency, namely Directorate of Revenue Intelligence. He has been part of the focus group involved with the second report of the Tax Administration Reform Commission, Ministry of Finance. He has over 13 years of experience in advising multinational and domestic companies on Indian indirect taxes. He has functional expertise in various Indian indirect taxes such as customs, foreign trade policy, central excise, service tax, and VAT. He is actively involved in advising manufacturing sector clients on indirect tax structuring issues. We also have with us Mr. Vinod Joseph, who has graduated with a BA LLB honors degree from the National Law School of India, University, Bangalore in 1998, with a master's in corporate and commercial laws from London School of Economics and Political Science in 2003. He is admitted to practice law in India and in England and Wales. Mr. Vinod started his career with Chambers of Zia Modi in Mumbai in 1998. In London, he worked for Girling WLG, Reed Smith and Kotak Mahindra UK Limited. After returning to Mumbai in 2011, he was a partner in Dua Associates, subsequent to which he has had a series of in-house stints wherein he headed legal teams at Bennett Coleman's Brand Capital, IDF Alternate Limited, and Global Infrastructure Partners India LLP. He joined the firm in 2019. Mr. Vinod has extensive experience in structuring and setting up private equity and venture capital funds, preparing fund documents, and obtaining requisite regulatory approvals for such funds. Mr. Vinod has also supervised and worked on many transactions involving investments by funds in Indian companies. Mr. Vinod has a vast experience both in advising both tech companies and entities which process large quantities of sensitive data, such as banks, in best practices and contractual safeguards. We really have a very star-studded panel over here, which is going to discuss on data protection. I now call upon Dr. Shashikala Gulper to take the floor as the moderator and begin the discussion.
Thank
you, Dr. Bindu. Good afternoon. It's my pleasure to have such esteemed panel, which is a good mix of audit firms, which is a good mix of multinational experience, having experts who are sitting on the boards of various corporates, and also those who are into hardcore litigation with a mixed experience of government as well. At the outset, the PowerPoint is running. The next slide, please. In the next slide, which is the very first slide, we are giving you, as part of my remarks, the general background. Why did we choose this curious case of data protection? We have certain background, certain developments which have happened in our country, as you can see there. One is the way in which our digital population is exploding. And secondly, the way in which e-commerce users are growing, and the growth projection of e-commerce and internet users. I have to add a couple of other things as well. The way in which mobile apps are being used, how the numbers are increasing, and the technology applications which are used in collecting, storing, and transferring the data. The way in which the data flow has been mapped in organizations and in individuals' lives. The second slide shows certain important developments which have happened. Before we move to the second slide, I want to bring to your attention one more important development in our country. Ours is the country which has the highest personal database, the Aadhaar database, which is about 1.3 billion. So you can imagine the significance of this topic in terms of the human rights focus, in terms of constitutional guarantees, in terms of also its impact on trade as such, and the simultaneous international developments which are happening. So we have had in India two important developments. One happened in 2017 with the Puttaswamy case, where Justice Puttaswamy, a retired judge, questioned the compromising of the personal, the danger of personal data being compromised, and the privacy as a right to, part of right to life, as a fundamental right being compromised because of the technology and because of the corporate actors who are in control of this technology and data. And Supreme Court agreed with his contention, and it was very clearly mentioned how right to privacy is a very sacrosanct right. The sanctity of personal data, and sanctity of personal data as organic, your personal identity information is as if it's part of your organic system. So this kind of sanctity was highlighted and upheld by the court. However, the implications of that judgment had to be read in the context of Aadhaar Act and the Aadhaar judgment, which came a year later, where again court, although agreed with the larger role that was played by state holding this data for public interest, it also restricted state's power in terms of holding this data by not holding it for too long, not to compromise in terms of transferring that data, etc. We had another development which came, in which one of our proud alumna was also involved, Supratim, because of the jumbo size of this panel, and we did the good decision of not squeezing him in because we didn't know the stage is so small. We had to keep him to respond later, who was involved with Justice Sri Krishna Committee, which was assigned the task of looking at Data Protection Bill of India in the line of the European and Australian initiative. Now, Europe and Australia, by the time of this judgment itself, had their data protection legislations. I must give you quickly a little background on European preoccupation with the right to privacy. We must understand that European preoccupation did not begin with Europe, neither in the insulated philosophy of the French, nor in the state-controlled approach of the British. It traveled from the other side of the Atlantic with the research of the Harvard researchers on identifying right to privacy for the first time. Once it was identified and articulated in scholarly journals, courts picked up on that as part of fundamental rights doctrine, and then separate right to privacy was asserted. And European Court of Human Rights in its various judgments has highlighted the right to privacy from late 70s onwards, So this is how the trajectory has been. So Europe has been, especially European Union has been very alert in data protection directive implementation in 1995 itself. But the challenge came from technology. The challenge came in the post-1995 developments with the upsurge of internet. Although internet was attended to in the data protection directive, there was a large explosion of use of cyberspace and revealing of personal information for various purposes. So at that time, it was felt necessary that all the member states of European Union agree on a common standard of sacrosanct privacy being protected with the onslaught of this technology and its power to control and centralize the data. The alarm bells were sent when bank complained of loss of data. So this is how there was a kind of war footing on which this GDPR was implemented in Europe. Now the ramification was not just to Europe, not just those who did business in Europe, but also those who did business with Europe. And companies, European companies, which are dealing with the citizens in other countries, and other countries' governance system as well as other countries' transactions impacting on European citizens. The danger was that there was an implication of huge fine which could be levied. And the fears were raised that with the implementation of GDPR, there is going to be an upsurge of litigation. That's why we thought that we will have a very good mix of panel which will look at the implication for trade, for finance, for cross-border interactions, for domestic implication, legal implications in terms of litigation, upsurge of litigation. I'll quickly give you just two data, just to set the stage and then hand over to our legal experts. One is that it was feared that there will be a plethora of ramification of this in the post-GDPR era. Between June 2018 and 2019, we read that there were 60,000 breaches which were reported. But out of them, only in 19 cases, the authority had passed its final decision. And one of them was the lethal one, the Google being made to pay $50 million as fine for keeping the data. So this is how the alarm bells were raised, and then the actual implementation is still far from satisfaction. I mean, it's very, very dismally small kind of implementation, but that's not going to be the scene. So all over the world, there is going to be, there is an alarm bell, and there is a kind of understanding that since consumer is the king or queen, and if consumer has to be protected, then data protection is very important. So if the consumer rejects you, your business is gone. So the more aware you are and concerned you are about that consumer's rights, then the consumer is going to consider you as a best player in the market. So against this background, I'm going to throw open the discussion. I think I should start with Vinod talking about what are the domestic implications for India of this data protection regime, and how the two legal developments of the Aadhaar judgment and Puttaswamy judgment are to be cast in this light. Let us just begin with the first few issues in terms of generic implication for India as a legal expert, please.
Thank you so much. I think to start with, I should say that we've had a data privacy law since 2011. The Reasonable Security Practices and Sensitive Personal Data Rules 2011 framed under Section 43 of the Information Technology Act. So the IT Act in 2000, when it came about, it was meant to put in place fundamentals for IT laws like digital signatures and those things. So data privacy was not anywhere on the radar, even though in the European Union they had a data privacy directive since before that, in 1996 or something. And yeah, so they had a data privacy directive. But in India, data privacy was not a big deal in 2000, so it was only in 2008 that they introduced Section 43A, and after 43A was introduced in 2008, along with a number of other amendments which introduced cyber crimes into the Information Technology Act, that in 2011 you had the data privacy rules with a very long name. I won't repeat it again. So we had a data privacy law for a while, but it hasn't had very high visibility. I know that till recently, if you ask the average Indian lawyer, does India have a data privacy law? They would say no, it's not there, and many people haven't heard of it. And one reason is that it's framed as a set of rules under the IT Act. So it's even debatable whether this would apply to data which is not in electronic form, because it was framed under the IT Act to start with. But it's been around, and to be honest, even though it's not very well drafted, it's drafted by a bunch of bureaucrats, but it's got the basic fundamentals of data privacy law that, you need consent when you take data, you process it in a way which is appropriate, don't keep it for more than the time period which is required. Those fundamentals are there. Now, with the Puttaswamy judgment, then the government had the responsibility of framing a suitable data privacy law, because what was there since 2011 was not definitely fit for purpose. And we had this shining star of the GDPR in the horizon. So the powers that we decided, let's take India let's give it a quantum leap from the dark ages to the GDPR standards, which is now where a number of issues come about, because are we ready for GDPR standard? Because the new data privacy bill, the 2018 bill, which has been modified a bit and came in 2019, it's practically GDPR standard with a couple of few crucial differences. But on the whole, it's GDPR standard now. And it's got all those dispute resolution mechanisms. It's got a data protection authority being set up. Significant data fiduciary should have their own data protection officer. It's a lot of compliance, so it's good news for lawyers. But as a society, is India ready for all of that? It's going to be a lot of, are we opening a can of worms? Is it going to be more trouble than what it's worth? I mean,
okay, Vinod, since you are basing your premise on the basis of GDPR, let me divert the question to our experts from the audit background,
sure.
Like Abhishek. If you could highlight on, under GDPR, what is the data and what is the kind of protection? So for the benefit of the audience, if they have not read the background and come, I think we have to build your argument on the basis of
sure.
that. So can I?
Please do that.
Yeah, please.
See, what I understand is that, the basic thumb rule remains the same. Data has been a subject matter of debate a decade back and even today. Even if we see the finance minister's speech today, she, categorically mentions about data and how this data is relevant is not only just to calculate the fiscal deficit and so on and so forth, but otherwise as well, right? So now, coming to your specific question, I think what is the theme and three parameters, as I would see, whether it is the global data protection or with respect to the Indian laws, I think one is, of course, the consent. There has to be proper consent as far as the personal data is required. So, if I want to share my data, either on an app or otherwise, is there a consent which is being taken from me with respect to my data, which is which could be very personal as well? That is one. Could not be just the trend by way of usage of location, etc., etc. And even when it comes to usage of the location, so I think the first and the foremost point which relates to it, whether it is the global or the Indian, is that where there is a consent. That is one. Secondly, I think ambiguity. Now, when all of this is shared or is desired to be shared, we just accept the terms and conditions on the app, and sometimes we even don't read those terms and conditions. And if we go and read those terms and conditions, is there appropriate way by which there is no ambiguity? So I think ambiguity is the second point. The third and the most important, which I feel, is that once, and I think it gets covered at both the places, is are you in a position to revoke that? So if you have basically given consent once for the data to be used, which could be your personal data, which could be other data, are you in a position to revoke that? So I think those three parameters are important, from both the perspectives.
See, you are talking at a level where the data under the GDPR, without the prior informed consent, data cannot be transferred.
Right.
my question is, what is the kind of data that could be sensitive? Under
Right.
GDPR, they have dealt with some
Right.
specific type
Yeah.
of data.
Yeah.
Just to highlight or take it further from your exposition on the legal dimension,
Right.
GDPR talks about the data on product, data on identity, data on web, on location,
Right.
and then it is talking about health, genetic data, it is talking about biometric data, it's talking about racial data, ethnic data, political opinion, sexual orientation.
Yeah.
So, as far as this data is concerned, it says that there should be only, what is the standard of reasonableness in that context?
Right.
Is it defined anywhere? How are we to decipher the idea of reasonableness, the reasonable protection?
I think the reasonableness and vagueness both are important, and if we see our apex court has held, especially in the case of Shreya Singhal, where it pertained to section 66A of the IT Act, and they uphold the doctrine of void for vagueness. So I think the most important thing today, if we see how the law would be perceived or how it will be drafted as of now, keeping all best international practices and experiences in mind, I think the most foremost thing is that the law which is drafted today, which is in the process, is not vague. So, whether so now if the clarity is there with respect to protection of sensitive information with respect to, let's say, my location, that needs to be defined. Like location used on Google, location used through the hotel booking apps, and so on and so forth. So I think the most important thing which needs to be considered while finalizing these rules, as far as India is concerned, to have a lot of clarity, because whatever said and done, we Indians have the tendency of moving to the courts quite frequently. So I think to avoid that and to provide better clarity as far as this data protection is concerned, we would not want that at various stages when the matter is being argued, doctrine of void for vagueness crops up. So I think from that perspective, whatever has been provided in that global data plan, that should be adhered to a very large extent, but in the Indian context with lot of clarity.
Now, in this context, I would like to ask Amruta, what do you think about the GDPR norms in terms of authority having the final say and the consumer having the locus standi? Do you think in the Indian bill they have proposed that only state has the authority to question that and not the consumer or the client? What is your take on that? From your experience as well as your study of GDPR and its Indian context, please.
So if, before I answer that question, let's go back to the genesis of the both GDPR as well as Personal Data Protection Bill which has come out. It starts with the right to privacy of an individual to its personal data. So what both the legislations are trying to protect is each individual's right to privacy. It's upon the state in each case to protect that. So let's look at Puttaswamy judgment itself. When it came out, it declared that right to privacy is a fundamental right which is given to each individual. So the state has the right to encroach upon that only in 3 circumstances. There's a 3-test fold which has been provided under Puttaswamy judgment. One is there should be a law which allows the state to encroach upon the right to privacy. Second, it has to be for a legitimate purpose or some aim which it tries to achieve. It cannot be a vague law or an arbitrary law which just permits the state to encroach upon someone's personal data privacy. Third is that it should be proportionate. So the law which is enacted has to be proportionate to the aim that it needs to achieve. It cannot be disproportionate. So like excessive data cannot be taken by the state when the purpose is extremely limited. So these 3 tests have to be met by any law which encroaches upon persons' data privacy. So if you see the bill which has come out in 2019, the state has been given wide powers to exempt its agencies from the provisions of Personal Data Privacy Bill. So that itself, like, Justice Sri Krishna was talking at a conference last week in Bangalore. He himself said that, that provision is likely to be challenged before the Supreme Court because of lack of constitutionality. So ultimately, the objective of both legislation is that, it's the right to privacy of an individual that needs to be protected. It is the onus of the corporation or an organization or the state to prove that they are complying with the norms which are required under each legislation. And it's not about, the onus is not on the individual to prove that, their data is breached or things like that. So onus is actually on the organizations. When they collect data, they have to comply with the legislation.
See, GDPR makes two distinctions. One is the controller of the data, and the other is the service provider or the processor. Now, if you look at that, keeping the consumer in the center, going by your argument, individual in the center. Although we have other jurisprudential arguments which are coming up about corporate human rights. Have you heard of that? Corporate as a person and corporate's human right. Although it is not human, it's notionally human. So corporate also needs to be protected under the GDPR is another jurisprudential notional extension of this argument. But let's confine to your argument of consumer in the center, individual in the center. I'm going to ask this question to Bhumika. What is your experience in terms of compliance as to who has to be having obligation under this legislation? Is it all corporations or all organizations, or is it only organizations which have 250 or more employees? How have you seen in your assignment with the international law firm outside India and in India, the preparedness and receptivity? I mean, let us say, before the bill comes, as researchers of impact of law in terms of impact assessment, how ready is our country or our business community, our organizations, vis-a-vis the other side of the world which you have been seeing as a practitioner? If you can give us the insights on that and what we need to do for such readiness. We have got this, what we call cyber preparedness, for example, which is technological preparedness, or global standards, for example. So you can take some of those parameters and enlighten us on that. Thank you.
So I would like to state that as far as India is concerned, what GDPR did was it created awareness. Yes, as rightly stated by Vinod, we already had our law in place. It's not that we never had. It came more to light over a period of time, and it's coming more into the picture now when we already have the statute, the bill, the Sri Krishna report and everything. But what GDPR did was, it created that corporate awareness. Till now, corporates never considered the business houses. When I say corporates, I'm not meaning to say the people working in these corporates, but the business houses as such, and they do not have policies even today when you talk about the data privacy or data protection. You name the likes of any of the MNCs in India who are working or who are having their businesses, they are complying now. Why? Because GDPR brought it up. So that's one of the biggest differences that you see working in the EU sector and when you're working in the Indian sector. That's one of the points. The second point is the statute that we have from the section that we get from the information technology and the bill that we have now, which is coming into the picture. Yes, it's exactly on the same lines as GDPR, but at the same time has its own differences. I mean, to point out a very minor one, so to say, they have it a data subject. What we have it as a data principle. Right, in terms of definition, how it has been distinguished from them is, because we are not putting an obligation on the individuals here. So yes, we are saying that it's the responsibility of the one who's sharing the data to maintain it, but if you see the statute, there is no statutory provisions with respect to them on that. So though it's a data principle, whereas they are calling the person who's sharing the data as a data subject. So, I mean, I don't want to get into the legalities of the differentiation, but the implications of that is going to come up on the corporates which we take advantage or benefit of. having this said, at the same time, it's a very good initiative for the corporates to now starting it, because most of them are now getting their policies in place. Most of them are now creating awareness in terms of the employees, which is already there prevalent as far as the EU companies are concerned, EU sectors are concerned, not only related to IT, but even if you see manufacturing sectors, right until the factory ground level, they have the data privacy norms in place. Whereas in India, even today, you won't find that at the factory levels or the ground levels. So that awareness is still building up and the policies are getting framed. So that's the distinction when you look at from two jurisdictions.
Thank you. Thank you. That's a very good way of briefly putting the distinctions. Now my question goes to Mr. Amol Bhat, because you are from a firm, PwC, which is having multiple verticals. So I was reading about 39,000 software applications controlling the handling of the personal data, and only 10% are visibly there. So I don't know if it is right to ask you this question, but I'm sure that with the kind of presence and authority that your firm has, you would be, I mean, I have trust that you would be able to answer this question. Now, if you're looking at privacy by design, inbuilt design in organizations, since you're checking on compliances, etc., how appropriate is the current technological awareness or a DPO, means what we call as multiple stakeholder task force in various companies which are working in India, or companies of Indian origin which are working in the European part of the world or in the Australian part of the world? How prepared are they?
Okay, so I'll start with the first part on the 39,000 apps that you talked about. I think first thing first, somebody talked about awareness. I think Bhumika covered that. Awareness at a consumer level needs to come in. Now, if I ask few questions here, how many of us really know what permissions have we given on the apps that we have on our mobiles? Okay, hand on my heart, 90% of us will not know what I have permitted to access on my system. Okay, so if something like that has to evolve, firstly, privacy by design needs to be implemented, which would essentially mean that I have a granular access control in terms of what and how much can be accessed once I install an app on my mobile. So that's the first thing. The second thing, this to really get fine-grained as a program in every app that's there on the App Store, it's going to take a humongous amount of journey and time. So essentially, consumers need to demand, and entities who provide these services need to evolve to ensure that they are able to support that kind of an requirement. So two things, yes, majority of the apps, what they do and how they do, we're completely not aware of. And as consumers, we need to be little better prepared and aware in terms of what and how much I want to share with the entities that are going to create these apps. And I'll just take one example and close. I can change a password, but I cannot change my biometrics. So if I'm ever going to share any biometrics, I need to be 100% sure that this will never be compromised. If that assurance as a consumer doesn't come to me, I am not in any mode to share any of the biometrics that are there, because I can't change a fingerprint, I can't change an iris, I can't pretty much change my face. So anything which is to do with biometrics, please don't share. Anything with respect to resettable values, please go and do whatever you want. I think that's what I'll kind of cover.
Yeah. Thank you very much for that. But now I would extend that question to Mr. Suresh Nair. You have had the experience of working with the government as well, and you would have seen in terms of how organizational preparedness for data protection, in terms of risk assessment, in terms of operational and other vertical assessment and preparedness could be practical in a country like ours. And how far does the current proposed bill takes care of that or responds to that need?
Right. So I think I'll touch upon two aspects to this particular thing, and again, this is based on my experience. If I look at the organization that I am in, so if I were to look at this, and if I look at the clients that we look at or service, One example, which is slightly off the cuff, but I'll just try and put this in perspective. Given the onset of GST in July 2017, and being in indirect tax, I'm just sharing that. Okay, so there's a smile on Sudhita's face. The extent of data that has got shared, transaction level data, is shared to the government portal, which is the GSTN. So, which means that an entire balance sheet, okay, which is there, can probably be carved out of the data, and it has to remain secure. Now, just taking to the question that, Amol was touching upon when you said about organization being ready, it has to be ready not just from having IOSI qualification so that you ensure that security is up to speed, total, okay? But here I have seen live that even the engagement letter, the risk management documents which are there, what you have to commit, okay? Because we work with some of, let's say, the best banks in the world, okay? The telecom sector, where KYC is the norm. There's nothing more than that. And to pass that particular test, and therefore I have seen, and I'll be very candid and honest, I'm really not an expert on this subject. I in fact read because of this particular thing, and I realized that the essence is driven, not just in the form of law that we are seeing, but it's clearly there. So to me, if you see the essence of data privacy, okay, data, it to be sacrosanct and to be protected is there, and organizations have. My only worry is that there's a difference between companies like, PwC, EY, other consulting, the big firms. Microsoft, I was told in one of the articles that 300 engineers were put in place to get their software in place to be aligned to GDPR. It will be the larger companies, I think, who will come on speed. Obviously, they know, they understand. I just get worried whether the smaller ones will have the infrastructure to come in place. So awareness, I think, is clearly there. On the other hand, I think for government, and the way I have seen this, there's been changes in this bill as well as compared to the earlier one when I was reading to that. It is definitely clear that government continues to hold the upper hand as far as their own role is concerned in this whole journey. I think they've been doing it. I worked in an intelligence agency for about 4 years in my career, and I think there is a reason to that, but I think it's about meeting the sensitivity, I think, of some of the inputs in the report, and how quickly, they can turn this around from a sensitivity standpoint. Hopefully, I think the Meenakshi Lekhi-led, JPC now will probably look at some of these aspects and tighten it as it gets to be placed before the Parliament.
Thank you very much. Thank you very much. I would like to request Sangeet to reflect on the dimension of how far this gap between GDPR readiness in India and GDPR necessity in the projects that you or your firm would have handled has been experienced by you. It will be very beneficial if you can take an example and highlight, if it's okay, or your general view on that.
Yeah, so few aspects I would like to say that, of course, that India is set to shape the digital economy, and government is focusing on now, like from the software service industry to software product industry. Now, in this context also, if I see the GDPR application and how to bring the industry at par with GDPR, still we are at lower stage. The reason behind, though the big industries, they can shape their data protection and policy, everything at par with GDPR, but especially with the startups. If they are serving to like European citizens, then obviously there are so many stakes and risks involved. The first thing, I will give you one simple example. Let's consider an industry where I have seen there is a service provider of software development. They customize the user interface. Okay, they customize the user interface. They build up the customized user interface for certain merchant who wants to sell products or services to, suppose, EU citizen. Now this particular service provider or software developer, they have the control of everything. Now I am the merchant, I got my customized website, including a software application, which is not actually owned by me, it is developed by some other developer. That developer also brings this application on the Google Play, or they can also launch the website. I have purchased even a domain name, which is suppose, like, I'm just taking the example of Amazon. I suppose I have Amazon. I have Amazon.uk, and this interface belongs to me. I'm the merchant. I'm selling the product. Here, if I consider the application of GDPR, I will become a controller because I am getting the information of mobile number, the consumer likings, their interest, everything on my portal. But on the business layer, it is actually handled by some other service provider. It could be the Indian company, it could be the European company as well. Correct. So if I consider the definition and accountability from GDPR perspective, I am the controller. I'm taking the everything. And if I go to the business layer, the person who is giving this service to me is actually a processor. So here I find the gap. So many Indian companies are giving the small entrepreneurs or proprietors with this application development service. But on the back end, when I see their readiness about their own infrastructure, because if you are giving customized portals to the merchant users, you have to see the compliance of GDPR. You should have the hosting services which may be encrypted, which has to be encrypted when you are transmitting the data from to other processor, because maybe this service provider has hosting services taken from other service provider, could be Microsoft. Yeah. So from that aspect, the small industries who are giving various services to small players, they are still far away from the compliance of GDPR, and obviously the economic effect of this will be far riskier. And for small industries, still they are not at par with GDPR.
Very good observation, and I really liked your point on digital economy, India moving towards which Suresh also told about digital economy. There is this UK information officer who has reportedly said that as the businesses build on digital economy, build on digital transformation, the businesses evolve. I mean, sometimes, they gallop. But whether they are also monitoring this, data protection, privacy rights, and all these GDPR norms, is there a compliance or not? I mean, a time has come when businesses need to be monitoring it on daily basis. That's what she says. Now, from that point of view, if we look at India's data protection bill, which they have mooted, I would request Supratima also later on highlight certain gaps which mightn't have been reflected by the panel in the limited time. Where are we as far as this is concerned as India, as a nation, or our industries are? I was reading the RSA report as well as the CSA report about this data protection concerns. So in the European context, we have seen that right now it is mainly about penalties being levied. What kind of urgency is being expressed by the businesses? So I would ask each and every one of you to reflect on that. Is there a sense of urgency? Is there a kind of what we call as global data hygiene standards? To what extent our businesses are following those standards as it is? As it is, there's a need to follow that, because ever since the passage of the Information Technology Act and banks and other big services making use of such servers and even moving their data. I mean, they outsource, as you rightly said, the local provider, and the local provider might be hosting the data outside India. So whether such situational analysis and status report is present, I'm also directing this part of the question to you, because you guys are preparing a lot of such reports. E&Y is preparing such reports. So what is the status now? I'm throwing open this question to each and every one of you to respond for 5 minutes, and then we can wind up the issue, making the two speakers to respond afterwards. So quickly, if you can tell us about, in your experience, the preparedness and the urgency and the way in which this risk has been assessed, or there is a kind of already process set in, or are we waiting for someone else to take care of it, like the virtual data protection officer, or are we able to create an internal mechanism in terms of compliance, self-compliance to these requirements?
look, again, I will give the answer for this question through example about the readiness and hygiene checking. I remember one case of Andhra Pradesh, which is very peculiar in this case. Generally, suppose when we go for our sale deed or leave and license deed registration, what do? We give the thumb impression, correct? And even anyone has the right to get that copy of leave and license and sale deed from the registrar office. I have seen like very, I will say, smart mind. They have taken the sale deed and conveyance deed of so many persons, around 6,000 persons, and they get the thumb impressions and every details. Even we sometimes put Aadhaar details in the conveyance deed. Now, if you see the hygiene perspective, what is the responsibility of that registrar just to get the registration? There should be a data protection officer who should actually redact or like cross-line at least the thumb impression part when we get the copy, or our personal details, which is also there in the leave and license agreement. You just want to see that who has the title, but you do not need to show the personal information of like lessor, lessee, buyer, or any person. So from that perspective, still I say from two aspects. One is from the aspect of training and institutions who can implement this. We are far behind from that. Though even we have a data protection officer in future, are they well trained for that aspect? Because you appoint someone as a data protection officer or anyone as accountable for data protection, is that person is really trained or understand the classification of sensitive personal data, or whether it is not a sensitive personal data. Another example I will give you, everyone has a mobile number. Okay, now this mobile number, if I see from as a single number or which belongs to me, okay, it's maybe a personal data, correct? But I use this mobile number with the Bhim application. If you see, your account user ID in the Bhim application is with your number @UPI. Now it becomes a financial information. So how I will design or how I will classify this data? Is it a simple personal data or is it a sensitive personal data now? Because we share this UPI ID with various persons to pay the payment. And we share with sometimes through WhatsApp also. Yeah. So still I see there are various aspects which needs to be considered, and we have still not reached that path to view from different angles.
So it's a very serious issue that you have pointed out, which is applicable to every mobile user. So may I have your viewpoint?
Yeah, I think
on the same issue.
See, I mean, of course, he mentioned the point about the data which can be capable of being captured from such things. And if you see, even another example is your boarding card for a flight. Tremendous information can be gathered even from the boarding card from that scan code. So, I think how I would want to see it, especially in terms of the preparedness of the corporates or other entities, is from two perspectives. One, these disruptions would happen and are bound to happen because we are living in a dynamic technological environment which is changing very fast. So I think the related point is that when we are living in such a technological changing environment, how fast we are to adapt ourselves. So I think the corporates and all the stakeholders, including all MSMEs, etc., who are required to do that, will have to adapt very quickly, to such a change. Because at the end of the day, there will be responsibility which will be cast upon to them. So I think the disruption, the adaptability question, and how much time is being given by the legislature to them will all be very important. But I think the most important thing is that it can initially maybe would come with some sort of a threshold, because 20% of all of these problems, 20% of these entities, etc., would cover 80% of those transactions. So will it be monitored in that way? That needs to be seen. So I think from that perspective, when it comes to the preparedness, the adaptability of these concerns should be much higher, so that we move towards a better society. So I think that's what it is.
See, the GDPR Act in Europe was necessary because of this only.
Yeah.
The disruption has happened,
Yeah.
technology has taken over, and we have to be alert now.
Yeah.
The thief is already here. we have to arrest before the thief damages us. So, or phantom. So, I would have more concern on your comment that we have to be dynamic, we have to be adaptive, and they will be made responsible.
Right.
What is the interim responsibility? In Europe, this interim period has been captured by saying that if there is any data theft or any kind of data transfer, it has to be reported within 72 hours. Now, is it feasible in a country which is still not even 50% digitally connected or digitally penetrable, whereas the data has already been taken in the name of Aadhaar being compulsory? Now, what are the...
In fact, before you go to him, just a small experience which I want to share. Just a couple of weeks back, there was a criminal matter which I was arguing in Delhi High Court, wherein one of the fact which was put before the court is that they have a recording of the call, and which showed certain things, etc., etc. And of course, the evidence was not tested there in court on that particular day. But the question which I asked to my learned friend is that who has given him the right to record that? Is the offense which is being, and I think that's the point which Amruta also made, is that to what extent it could go. So I raised that objection that, of course, you know, it may have been recorded, it may have certain facts, evidence, etc. But does he have the right today to do that, right? And has he taken all legal permissions to do that? Yeah. So I think that becomes very, very critical when it comes to a lot of these evidence gathering and all of these criminal proceedings and so on and so forth.
This is one issue I would like Supratim to highlight, the right of the state to conduct the surveillance or assume the power, you know, call CDR records, you know, call directory records. Okay, I mean, that is argument that has been predominant in Sri Krishna committee as well, that in public interest, in Aadhaar case also, in public interest for social benefit, you can compromise on data. So let's leave that question for him to,
in fact,
as a challenge to him.
I will share an experience with my previous organization where the junior recorded the conversation with the senior, right? And showed it to HR that this is how, you know, this senior misbehaved, right? The HR told the junior that who gave you the right to record that.
Excellent. That's because it's a law firm. In other organization, it will pass off. Yeah. We have so many media making stories out of it, you know, all these kind of call directory records. Yeah. So let's have your view on...
I'll try and keep it simple. So I think I do appreciate, if you're saying that having a law, whether it will, just because you have a law, whether it will protect against any crime or against any misuse or abuse, the answer is no. It is meant to protect. But let's take one particular thing. Are we thinking through? I do understand this, you know, the land issues. But is the government learning? Is the government sincere? I will tell you it is. It's a journey that we need to be patient. We are a huge country. I'll give you just one example. Look at GSTN. You cannot access the IP from a foreign IP. You cannot access the portal. Look at, I mean, our own solution. Overseas, if you try and access, no access will be given to you at all. Which means they know that the possibility of a hindrance is there, and therefore, so if you look at the NIC portal for e-invoicing that you're talking about, try logging out from outside India, it is not allowed. So these are very smaller means, you will say, and I may be myopic thinking about my own field. But efforts have been done. About surveillance, I know it's a huge sensitive issue which is there, but if you look at the amount of, you know, good cases, absolutely uncrackable cases been done in the backdrop, it's about fine line of balance. I think support is required. And you may say, because I come from a background, which is why there is a, you know, still probably in Roman, thinking Roman. But I think it is a balance that we'll have to do. We'll have to learn in the process. I think we'll have to educate, and that's important. What's missing today, I believe, to get prepared is I don't see the reach out. In fact, a person like me who deals with law has not read this in detail. Till this, you know, session I had to come here. So if you can educate, if there is more that government will do in this process, is where I think, you know, it will take us to the next level.
So shall we also educate on the right to be forgotten in addition to being educated on the benefit of giving the information?
No, so yeah, I think awareness is not just about one particular area, it's pretty much everything. If I have to put it in a different perspective, it's a journey. The journey will take, and as what Suresh was saying, the journey will take some time. If we start scrutinizing every aspect of it in a threadbare manner on day one, I don't think we'll ever achieve any of the results. But I think the government is mindful, and as responsible citizens, we should start doing our part and together move towards a more secure, digitally secure identities for not only citizens but every transaction that we do. So it's a journey, it will take time, awareness is critical, and the last part is it's not just the government, it's about every individual and every person and every corporate in the ecosystem who collectively needs to move towards it. From a readiness perspective, we are 3 on 10. I think it's a long journey to really make.
But because you are also a qualified company secretary, Bhumika, I have this question for you, that he was raising a very important issue, Sangeet, about some of these small enterprises, etc. How do you see this becoming advantageous to small and micro enterprises, and what are the disadvantages? For example, they say that anybody compromising the data is not at all forgiven by the consumer. Okay. And the study also shows that a large percentage of GDPR compliance was necessary in the area of, or those who are using technology, you know. And then it was online services, then e-commerce, and then we had IT, etc. So how do you look at the readiness and the standardization?
So again, in terms of preparedness, I would like to divide into the India and the GDPR that we are seeing, because there's a vast difference in the two. In terms of preparedness there, apart from, again, it's individual level and at the regulatory level. So individual level, I think we have heard sufficient examples at various learned people here, so I don't want to spend more time on that. But coming to the regulatory level, now, though GDPR, if you see the wordings, it only says it's not a binding or a regulatory wording. It says in terms of amplifying or assisting, or it's a kind of mode which gives a platform or a portal to take it forward to the level. So, but having said that, even though there are regulatory authorities who are monitoring, there are regulatory authorities, to give you an example, in UK there is an authority by the name ICO, which is Commissioner's Office, where they have already launched a sandbox platform, where they are already inviting people, inviting corporations, inviting small enterprises, as you rightly just named, to come and explore that sandbox opportunities. They help you take those experiments, they share those results with you. So which is a true implementation of GDPR when you see at the European level. Of course, now UK is not part of it, but that's where it started from. Whereas when you come to the India level, now if you see our privacy code which is there, or the bill that we are still talking on, it provides for the authority who needs to be appointed, that there'll be officers, that there are going to be forums, that there are going to be commissioners, but it's silent as to who appoints them. So it leaves a very basic lacuna question there as to, we don't know who's the appointing authority. Does it mean that it goes back to the government? If it goes back to the government, then the government appoints their people to that. So is that what are we talking about? So in terms of preparedness, from a regulatory perspective, we have a long way to go. In terms of preparedness, from individual perspective, as we heard it, it's something which we need to be more diligent and divergent on. Yeah. That's what I would like to put.
I would like you to comment on the dimensions, if any, from what your earlier speakers, panelists have said. But my specific question to you is twofold. One is, what is going to be the impact of this on the job market for law graduates? And second is going to be how the legal profession is going to be affected by this. But I also have some counter viewpoint to you. The counter viewpoint is, those who disclose data have gone on a countermeasure of falsifying the data or not fully disclosing the data. Okay, it is consumer's own self-preservation that consumer is using. The other counter viewpoint is that self-compliance, you know, what we call as voluntary compliance is better than external compliance, right. HLA heart, internal and external. So I would like to listen to your views.
Okay, so first I'll start with commenting upon, at least adding my bit to what already has been said about preparedness. So I would like to split it into 3 parts. So there is, one is an individual whose personal data is being processed. So their awareness. Second is the organizations who are basically data fiduciaries, as they are called in the bill, or data fiduciaries or data processors. And third is the judicial system which needs to be put in place, or the data protection authority is what's being called under the bill right now. So all these three categories of organizations need to be prepared. So first is we look at the organizational level. Who are the data fiduciaries? So I think as far as their preparedness is concerned, we are very, very far away from what is ideal, because if you see GDPR as well, and as Bhumika has mentioned, that the preparedness is at a much higher level. But when GDPR was adopted in 2016 by European Union, 2 years were given to the data, to the European organizations, etc., to be prepared for GDPR. Something like that needs to be there in our data protection enactment as well, because time needs to be given. Second thing that we need to look at is the kind of rights which have been granted and kind of obligations which have been cast on the data fiduciaries. So things like privacy by design. What is privacy by design? I don't think many of the small organizations are in a position to understand. Tomorrow if the data breach happens, the notification has to go on. For that, internal systems need to be in place. Then again, I think Abhishek spoke about consent. And the consent needs to be withdrawn in the same manner in which it's given. What mechanism is required for that? Then a query had come to me in respect of GDPR a couple of days ago, where GDPR says that the consent of the guardian is required when the data is collected of children more than 13 years old. So how is that to be taken? Because it says it needs to be reasonably collected, but what is the process for that? All that has not been laid down. So there's a long way to go for under GDPR as well as our data protection bill, where the implementation will be possible. And coming to the second aspect, that is the judicial aspect of it, a lot of it has been left to Data Protection Authority to legislate. Because if you see the text of data protection bill right now, it says as may be prescribed. Half of the things are to be prescribed by the data protection authority. When it will be done, in what manner they'll come out, and the data protection authority is going to be appointed by the central government. So there's not going to be much input from the judiciary or the technical experts, etc. So what they are going to come out with is not very clear. So from that perspective, being prepared today is not possible for the organizations. And also there's going to be an appellate authority to be set up, the tribunal to be set up. It's going to take time to put that in place. So that is again going to be like, in terms of that preparedness, we are nowhere close by. And the third thing is individuals' personal data and the individuals, how prepared are they? So the most important thing is education, like educating individuals as to what their rights are, something that we have already touched upon. And as far as legal profession is concerned, there is a lot of data, personal data, which is being collected by legal professionals today. In litigation, in contracts, and for mergers and acquisitions, they are going to make an exception, but that's what it seems from the bill. But as legal profession, it will be collecting more and more personal data. So legal professionals need to be aware of what are the requirements that need to be complied with, and the technical support needs to be there, because at back-end support is extremely important because that is something which is provided under the bill. And as far as students are concerned, I won't be surprised if there is a separate practice area for data protection which will be there. So it can be a separate specialization and self-sustainable specialization which may come up in a year or two maybe.
Great, thank you. But Vinod, I was also reading about internal task force, not to be just legal vertical, but multiple vertical like finance, operations, marketing, that's one. But what I am going to ask you is, aside from responding to these issues, main response I expect from you, because you began with the states, the 2 court cases and the way Indian government has initiated its response to this global development. whether state is only a facilitator or should state be held liable? Should there be a restriction, as earlier speakers have pointed out, in states' use of citizens' data? How do you balance this? Whether the current bill is balancing or not, both of you, Sachiv and Shupratim, can respond by saying things like copy should be stored in India. Judges have also said this. What is your take on that?
Sure.
Because that will be the last comment from the panel, then I'll invite the responders and then we wind up because people are waiting for the lunch as well.
Yeah.
So
now the state defined in Article 12 of the Constitution is a very funny animal. On one hand, it's more powerful than anybody else. We expect it to be fully responsible, but in many cases, the state is also a market player, and the state runs many commercial establishments, it runs airlines, it's in a number of activities which it needn't be doing, but sometimes it does it for the larger good. So the state is there, and there are certain functions, sovereign functions like law and order and the external security, where the state has an omnipresent role, and the state has to be all-powerful. Now, it's easy to criticize, but in certain cases, the state needs to have the power to take or get control over personal data. You can't always suspect that whatever is done by the state is wrong. No. The state, you need to give it the benefit of doubt in many cases. Of course, the state is bound by the Constitution and all other laws, and as Puttaswamy's case, as was ruled in the Puttaswamy case, when it takes over personal data, it has to do so pursuant to a law. But the current data privacy bill is a law, and it gives it power to do a number of things which the previous draft didn't do, which I think was the better draft. Now, should the state have so many powers? Should it be unchecked? Well, if it goes for judicial review, if it's scrutinized by a competent judge, will it stand scrutiny? Again, it's all open to question. But I think the state should have power to intervene. The state should have power to extract data when required for important sovereign function. But again, it should be with a number of checks and balances. So it definitely, see, data privacy is something which has come out of a cultural need. Traditionally, when we lived in joint families, when we all clung together, privacy was not considered with such a big need. Now, as we've evolved, as there's been more economic prosperity, when there's enough food to go around, we are more preoccupied with other matters, and data privacy is one of those things which is now more and more important. If 2 centuries ago you had asked people how important is data privacy, they would say no. If you're a prisoner, and the worst form of punishment you can get is solitary confinement, where you get a lot of privacy, but you don't want that. So
then the question is, see, whether state's way of collecting, you said state has a larger role to play to deliver social benefit. What if state uses an artificial intelligence mechanism which will be diluting these rights? Like, for example, if it commits an error of not identifying the one who really deserves the social service benefit. You know, we have face recognition technology which can be ethnically differential, you know. So how do we make state responsible in this so that sacrosanct principles of the Constitution, and as the guardian of that sacrosanct principle of the Constitution, we're having a duty, state will fulfill those norms, you know.
So misuse of data can be intentional or unintentional. And again, irrespective of the technology available, misuse can take place. Now, when there is technology, when there's more and more technology, especially AI and all that, the potential for misuse is much higher. You set the algorithms in a particular manner, you can build in a lot of bias. So there is all the more need for greater scrutiny, greater control, which is where a strong judiciary is absolutely vital. Because if you don't have that, you can get into a lot of trouble. But
Thank you, Vinod. So that clearly shows how the legislative approach and the judicial approach seem to be a little divergent, but how judiciary from time and again adjusts this machinery to fulfill the constitutional goals. So now let me invite the 2 responders. I would invite Supratim first, because he has worked in the backdrop of the Sri Krishna Committee, Justice Sri Krishna Committee. So I request you to quickly wind up your points. You could come here and speak as per your convenience. Yeah. We are really running short of time. Bindu was reminding me, so I request you to, sorry, you may have a world of things with your experience to say, but in 5 minutes, if you could capture those points.
So, firstly, thank you very much. And yes, I can continue for the rest of the day. But you know, I think Sachiv and I have a very grave duty right now. We are standing between you and lunch. So I'm completely mindful of that. The discussion till now has become, I think, kind of a little heavy. So let me share my thoughts on the points covered through some practical examples, okay, which we have come across whilst we have been already implementing several aspects of GDPR, and some organizations are getting future ready with the PDP bill as well. One was a hotel example where we were trying to prepare them for GDPR compliance, and we realized that humongous number of guests were from Afghanistan. So everyone was lost, like the organization itself, that how is this possible? We were trying to decipher how many of them were from EU. And then we realized the issue. The issue was the person at the front desk did not appropriately select from the drop-down menu, whilst a person was checking in, which country the person belonged from. Incorrect information can never lead you to do correct data analysis. Classic example. Example 2. We were doing, so just before 25th of May 2018, the night before, gentleman comes to my office, says that boss has sent me, tomorrow GDPR is coming into effect. This is my terms of use and privacy policy. Just make those minimal changes. I'm uploading it tonight, so tomorrow morning we are GDPR compliant. I had coffee with him, and I explained to him that, this is precisely what the law doesn't want you to do. No lip service, please. You have to really work towards it. There's a lot of activity, a lot of action which goes behind, the entire gamut of things that, that we spoke about right now. But one interesting thing, ma'am, which you touched upon, and I quite liked it, is that I think technology has made us come to this stand where we have an extremely complex law to deal with. But the good part is that the technology itself is providing solution for that. For example, dashboards, which are now kind of helping individual consumers to just log on to the system, check what details the company has and an institution has, make those changes and get going. But we need to be careful there as well. Because GDPR is, say, 1 year plus now, and we have a lot of experience from there. We observe that in the EU, there has been a lot of data pilferage, theft, where people who are not the actual owners of the data have logged on to the system and taken out information about others. It's a good thing for us because we have like 2 years at least lead time, which GDPR has already covered, so we learn from their mistakes and kind of rectify our system. Coming to the difference between this GDPR and PDP bill. So this bank came to us and said that we are following the gold standards of the world, and we are fully GDPR compliant. So I don't think we need to really bother about the personal data protection bill. But however, our leadership thought that we should do just a final check that are we completely okay with the upcoming bill as well. So we started discussing about the practices and procedures that they have followed. Basic differences. Age of consent is 18 years in the country. Under GDPR, it is 16 years. It can go below up to 13 years. It was not properly written in their policies. Right to be forgotten is completely different how the world perceives it and how we have put it in our bill. So right to be forgotten globally is basically we would erase everything to the last dot. But when we deliberated this with Justice Sri Krishna, we said it is extremely difficult in an organization to sign off that I have deleted every trace of you in my entity. But what is the menace that you are trying to really curb? It is right against further, further processing or further disclosure. So the way our law covers it is we will not further disclose or further process it. And that, I think, is a better way to handle the animal. Breach notification. Very, very important difference. Almost every global law has about 72 hours to respond to and go out to the world and tell that I've been breached. We deliberated with the entire committee and explained that in a tech environment, in 72 hours, you would understand nothing. So the way we have put it in the Personal Data Protection Bill is a very graded approach, and I think it's a win for Indian legislation because we have not aped the GDPR here. What we have done is we have said that you go to the authority, inform what has happened. The authority and there's a decision which is made, and then it is possible that you may have to go out to the world or wait for further information and input, and thereafter you would be taking the next steps. So, and on the preparedness perspective, I would say yes, there's a lot of gap, there's a lot to be done because things are not told simply to us. We just spoke about privacy by design. It's like Hebrew to several boards. I have, personally spoken to several, boards of eminent MNCs and realized that the board members are not aware. So, give simple examples to teach students, to, people that you are aware of, to decision makers. The simplest example of privacy by design is when you go into a restaurant, you will see some of them will bring you a point of sale machine which has got a cover, some may not. So the person who thought of a point of sale machine with a cover actually kept privacy in the center of everything. So whenever you are taking any decision, whether it is a good, a service, whatever you are developing, just keep privacy in the center of things and the rest is sorted. Education in this simple form is the most important thing. Otherwise, it's kind of Greek and Latin for several people, including, say, from students to the highest decision maker. So I have a lot to say, but I would wrap up here with just one more example which I had in mind of how we should be sort of educating to the last person on the ground. In one of the hotels in Bombay, when I was recently checking in, I saw that there was a quick check-in facility available at the reception where a laptop like this was kept, and just below the screen someone has pasted the password. It was written on a post-it and pasted right below the screen. So do you think that the organization did not take appropriate measure? They have taken all technological measures. But the human link happened to be the weakest link here. And that is because we do not educate our people who are handling these appropriately. So I think these are the few points that I had in mind. One last legal point, which I just picked up from your, Mr. Joseph, is that we spoke about 43A. There is another section in the IT Act, which is section 72A, which is talking about personal information, and that's a larger bucket than sensitive personal information. Now look at our legislators. In this personal data protection bill, they're trying to do away with with section 43A and the sensitive personal data rules. However, they have completely forgotten about this parallel mechanism of section 72A that is there, which is still there, and they need to delete it if the PDP bill has to come into effect in its present form. What we are doing presently, at least personally I'm doing, is collating all these sort of lacunas, loopholes, etc., putting it together. I've already sort of spoken personally with the MeitY, with the committee, with Justice Sri Krishna. We are trying to go and make a special representation before the Joint Parliamentary Committee of 30 members and see, at least we plug in these loopholes before it becomes a law, because it is going to impact every one of us, from the Panwala to the largest telecom company. Thank you very much.
Wonderful, Supratim. We are proud of you. Sachiv, if you can quickly give your comment, then we can wind up.
I don't think anything else is left right now after Supratim has said everything, so I don't know what to cover. I think I'll touch upon one point, I think, which was there on the slide but has not been spoken, I believe, the who owns data. I think there was a question. So I think the who owns data, the answer is the data principal, because if you see the bill, clearly there are sections with respect to rights of the data principal with respect to how to use the data. And if I go to section 24, 20, and 25, 26, 27, 28, it says you have right to be forgotten, there's a right to correction, there's a right to portability, there's a right to know where breach happened. So you own the data, you have all the rights to deal with your data. So there are instances where the breach happens, like how Supratim was telling me that, telling us that when a breach happens, then you go to authorities. But the bill does not talk about that the data principal should be also informed. It's the authority who will decide first whether it should be informed to the data principal or not. I think this is not correct. Sometimes you might decide not to inform. So it's my data, you inform me, at least my breach. And we have all been talking about consent. So now our bill is very stringent. It is one step further from GDPR, because when we talk about consent, the consent needs to be very specific, clear, and informed. And when you are talking about sensitive personal data, then the consent has to be explicit. So what do you mean by explicit? So the preparedness and the strategy with the corporate or the data fiduciary has to evolve, like a bank. If a bank is going to fill up a KYC form, or if a bank is coming up with a list of KYC things to be ticked up. There has to be a specific box over there with respect to your sensitive personal data. So everybody has to clearly and explicitly tick those marks. You can't make it ambiguous. So all the form for the loan application form also has to be very clear. So that's what with respect to consent and with respect to the rights of data principle, there are certain ambiguities I will just try to run across. So in the bill which has been revised in 2019 also, and in 2018 also it was there has been no, I think, explicit time which has been mentioned for the purpose of data retention. So for how long a data can be retained, it still has not been covered. There is no responsibility to the data processor to inform the fiduciary. So in cases where data processor and fiduciary is different person, there is no obligation per se. So there has to be contractual arrangement between the fiduciary and the processor. So that is not very clear. I have read, I have not seen this provision which talks about that when you give this data to a processor, whether he has an obligation to notify the breach. Then there is a brief summary of process to be followed by the organization, that how they process the information has to be told to the data principal. Meaning if you talk about previously about design, you have to talk about how you process the data and you have to take their consent. So there is a brief summary which you have to prepare, but what would be the content of the summary, that is not mentioned. So organization can choose to have that kind of summary on their own. So, and then again we are talking about consent managers in the new amendment bill 2019. So a data principal through a consent manager, which is also appointed by data fiduciary, can give a consent. So who actually can be these consent managers? Are they different from the data fiduciary? Is the question. Only one thing which I would like to answer, I think this question was raised by Bhumika, or I think you were talking about that the authority is appointed by the central government and there is no say by the state. I think the
state, I mean, there's no say by the judiciary.
Yeah, so if you see the new bill, the provision has been added which says that the authority will be appointed by central government, but the selection committee will be comprising of Cabinet Secretary as the chairperson, Secretary of Department of Legal Affairs. Correct. So judge, but the legal department is there. I think the chairperson of legal affairs is there. So they can.
Not really. They are not always qualified. I mean, I have worked with the ministry. I know how it is.
Okay, fine.
Yeah, there's no justice concern there.
Correct.
There's only efficiency concern.
So I think almost everything has been said. We have deliberated a lot over here, and our eminent panelist has already enlightened us with everything. So what I can say last is that no law can be foolproof. I think the attempt has been made to make it more stringent, rigorous, but there will be lacunas, there will be loopholes. Let the law come. We are talking about preparedness. I think we are prepared. I am a very positive person. I think we are prepared, because once the law comes, then the rules will come. Then
Thank you, Sachiv. Thank you. I'll have to cut you short because we are really. Thank you very much. I don't think we are prepared from the panelists. Reflections, I mean, we are prepared to some degree theoretically, but in practice, for a humongous population and the complexity that we still can improve, as Supratim was pointing out, even at a basic level and at the advanced level. Now, I would draw your attention to the quote, and that explains everything. The one who puts privacy in the center, I mean, who doesn't like the Apple products? Because you are in control, you are empowered. But what you don't know is they are also in control of your data. Anyway, maybe privacy and putting privacy in the center, as Supratim said, I mean, that's a crux that one can take home, is the most important one, which not only results in compliance to the human rights that privacy encompasses, as the Supreme Court said, combining the rights of dignity and liberty as well, and right to life, quality life, but also business success, as Apple has revealed. Second thing is that we have a long way to go in terms of preparedness. There's a good business opportunity from what both of them highlighted and the panel highlighted, that in India we are going to have data protection, need for data protection officers, data protection processors, And as it was told, technology itself is providing the solution, so there's a very good opportunity for jobs and businesses. So with this positive note, I'm very happy to conclude the panel, thanking the esteemed panelists for their wonderful contribution. I hope we have done 360-degree, and whatever the 60 degrees which were left have been fulfilled by our responders, especially both of them have been very effective, and particularly I thank Shupratim for his all-round reflection from the operations to the implementation of the policy. If there are any questions from the audience, 1 or 2 questions are welcome, and I would direct it to the panel, over to the audience. Thank you.
My question is open to the panel. My name is Shivani. I'm working with Artist Partners. I have a question with respect to the budget 2020, which where Nirmala Sitharaman had announced creation of data center parks with respect to the data localization circular which was issued by RBI, and creation of policy for the data center parks. So my question is, what can we expect from such data center parks?
So I'm not sure what does the data center park really mean, but what I can say here is, for certain purposes, data needs to be localized, and we're not going to get into whether it's GDPR, PDP, or whatever, but it's essential and critical from an country security perspective that data needs to be in India. How it can be done is basically we need to have the ecosystem to host that data in India, and that is what it is really targeting to do. Just like what we will have an SEZ, which is an export oriented, I think these data center parks will essentially help entities localize data. Why it needs to be localized and whatever the reasons, let's not get into it, because there are good and more number of reasons to have certain data in India, and that's sure. There'll be people who will say that government is not doing the right thing, let's not get into that, but data needs to be localized in certain cases, and for implementing that, whatever infrastructure could or would be required is essentially what will get enabled through these parks.
No, I think just in the interest of time, I think this theme has been continuing. Just that what this budget does is that it's always said that you go ahead and talk about something, but you don't have a mechanism to administer or put it in place and support. And to me, what I see in this announcement is that particular theme. Otherwise, data in India, as I said in GST, and it's a classic example of tons of data being available, but very much in India. So I think that's
Yeah, just to add this point, again, better I will share the experience why government want data localization in certain cases, especially the sensitive personal data and when it relates to the financial information, because so many fraudulent transaction happens online, and many times it is executive officers, they want to retrieve the data. What happens if the data centers are not in India, it's supposed in USA or California, and when the Indian officers cooperate with the foreign officers or like any companies, they are reluctant to share the data and they do not provide anything. And there are two aspects. One is to provide the data, and second, that you have to provide a certification that this data is correct. And so that has an evidential value. Now, if you don't have data centers in India, as I said, it is difficult to retrieve the data, and so if the data centers are in India, the public authority, they have like search and seizure, they may take the hard disk. In hosting services, there are again two categories. One category is that you just give a place, and each company may set up their own data servers, and the place works on the co-location. Second aspect is there is a data servers which itself works as a co-location. A company owns it, but they provide the segments of data servers to various companies. So if government wants to enforce and collect certain financial information and to retain the sovereignty over the data, and especially the financial data, data center should be in India. And we have the biotechnological parks, so many parks, and obviously that data center parks will again very, I will say, a good factor from the economic perspective as well as from the perspective of data sovereignty. Thanks.
With the permission of ma'am, if I can just add one sentence. I know we are running short, but since the question came and we had a classic example, again, not very long ago, a few weeks back, one of the clients approaching a foreign entity doing online sales in India and doesn't want to maintain the database here, wants it at the head office, everything. So that answers your question on data center, whether we need it in India or not. Your customer base is India, you're selling the product in India, you're using our data, but you don't want to maintain it here, you want to maintain it back home.
Yeah.
One more question? Yeah, just last, after that, one more, and then we close the discussion because we're very late for lunch. Yeah, please.
Yeah, I have that one question about that. Who owns the data? I think this has been answered by the Mr. Sekyu also. But the second point about what I get from this bill itself, that it talks about the data fiduciary. So can we say that data fiduciary is the person who collects the data or who processes the data as per the bill? So can we say that when we are using the terminology data fiduciary, it creates a trust, the person who is giving the data, and that person who collected the data become a trustee, it has to be used for the benefit of that person who is giving the data itself. So can we say that this the data owned by the trust, that created by that act or all?
I don't think there's any trust concept which has been created under the bill.
Data fiduciary.
No, the
word fiduciary is about
fiduciary
trust.
word itself creates a trust between the person that
correct. That's the trust.
Yeah, let him respond. He has seen the 360 degree.
Yeah, so I think that assessment is correct. We do not want to call it out actually. Honestly, we don't want to call out who's the owner of the data. And I'll give you some little more background, but yeah, it's the intent is to create a relationship of trust. Okay, that's the reason we don't call them data subjects and data controller, number one. Number two, why are we possibly not calling out who is the owner of data? If you see the new amendments that have been carried out to this particular bill, it states that the government would be taking some form of anonymized data from both data controllers and data processors. Now, of course, everyone is objecting to it, but there is an intent of the government to, at the back end, take some of this information and utilize for whatever purposes. There are several which have been listed out. Some of them are extremely vague, which makes us really uncomfortable. But that could be one of the reasons that we are not calling out who is the owner of the data.
And just to add to Supratim, and since he has already answered that, there's also the concept of data auditor which has been introduced. And that along with the data auditor is the data score bank. So that's something very unique to India. That's not something which is covered by the other privacy laws. So that's where the concept of the creating the trust concerns, and rather than leaving the ownership on one side.
Thank you. Shubhajit, he was wanting to ask you.
I'll ask the question to Supratim only. So under the new PDP bill, will it permit us to get the adequacy status under the EU law, wherein EU firm can store, process the data in India?
So the ultimate goal of this law, if you see why we have created this akin to a European law, is to have a standard equivalent to the European standard or EU GDPR, okay? But today we do not have that equivalent status at least, okay? We have to sort of watch out how we really implement it, and at the end of the game, if we are able to say that, we will have an equivalent status, just like Japan has, right? We are actually attempting to be there. That's the reason we are implementing such a complex law, which was never there. So for EU, we were just chatting before this panel discussion, that for EU, they already had a law. It was one step up when GDPR came into effect. For us, it is a quantum leap. We had nothing almost. From there to a GDPR equivalent, but there is an ultimate, reason for this. And the reason is to have greater business fluidity. As far as data flow is concerned, I'm hoping that that happens. Really.
That's what one of the things was, the adequacy will be there very soon, but then they have not given any timeline or anything.
That it is not possible. Given the present status of things, we'll have to first implement it and then go for that. Thank you.
Absolutely, I agree with that. So thank you very much. Thank you, audience, and thank you, panelists, once again. It was such an intellectual delight to be enriched by your experience and your enthusiastic participation, particularly our responders. Thank you very much.
On behalf of Symbiosis Law School, Pune, I stand here to thank all our panelists here. Thank you very much for providing such an enriching deliberation over here. I think we could have continued for a couple of hours more, but since time does not permit, we have to conclude here. But a very sincere thank you to all of you. I will also take this opportunity actually to thank Mr. Sachin and Mr. Supratim. Thank you very much for responding and being part of the deliberation. Our very special thanks to the education partners, the guests who have come from various law firms, industry, the alumni who is there present with us, the law aspirants who are there with us. I will also take this opportunity to thank the top management for all the continued support that we have from them, Dr. S.B. Mujumdar, Chancellor, Symbiosis International University, Dr. Vidya Yaravdekar, Pro-Chancellor, Symbiosis International University, and Dr. Rajni Gupte, Vice Chancellor, Symbiosis International University. I will take this opportunity to thank Dr. Shashikala Gulper. She's a person with a vision, she's a person with passion, and she does things with such commitment that it has led Symbiosis Law School to new heights. I thank Dr. Gurpur for all the encouragement, support, her vision, mission, commitment to the law school. Thank you very much, ma'am. Our faculty team at Symbiosis Law School, Pune also needs a special mention, and the team comprising of Ms. Sudipta Chakravarti, who's a distinguished visiting faculty at Symbiosis Law School, Pune, Professor Garima Panwar, Professor Amol Sapatnekar, Professor Ashutosh, who also look after the placement cell, and my colleague Dr. Atmaram Shelke. Thank you for all the encouragement and support that we get. Our network administrator has to be thanked, Mr. Amit Jatale, for all the support that he has been providing. A very special thanks to our student team, without whose support, organizing an event like this becomes very difficult. Thank you very much. Once again, thank you one and all. And I request all of you to join us for lunch. Thank you.